It is highly questionable whether a child should be given right to life when it is a fetus. A fetus is a human organism in development until birth. In our Indian constitution, a fetus is not covered under Article 21, which is right to life. It means that in India, the fetus will not be provided with the benefit of Article 21. It can only be provided when it comes into existence. According to World Medical Association, the life of an individual human being begins with the conception and ends with the death. Therefore, if the heart starts beating of the fetus inside the womb of the mother, then it clearly signifies that the fetus has got a life. Hello everyone, this is Farhat Naeem and you are watching India Legal. In this video, we'll be discussing about the recognition of unborn child, history of abortion and rights given to unborn child in India. So watch this video till the end. The care towards the right of an unborn child and its life can be seen in the Draft Declaration on the Right of the Child of 1950, which states even from before birth. On 2nd September 1990, the Convention on the Right of Children came into force. It is the first binding international instrument embodying international legal recognition to human rights of the children. It mentions every child's right to life and survival, to be of a nationality, to an identity, to be heard, to freedom of thought, conscience and religion, and to health. However, the convention is silent on the age at which the childhood begins and unclear regarding whether the rights reserved to children under the convention apply to the unborn or not. Article 1 of this convention defines a child as every human below the age of 18 years unless under the law applicable to the child, majority is attained earlier. This definition allows several interpretations of when childhood might begin under the convention: at fertilization, at conception, at birth, or at some other point between conception and birth. The convention's textual ambiguity calls into question the legality of abortion under the convention. And let's say if an unborn fetus is a child, a person, then under Article 6, the fetus would have inherent right to life. But the possibility of a fetus's right to life conflicts directly with the rights guaranteed to a pregnant woman under the convention only, which safeguards her right to health, to life, and to conscience of her best interest if pregnancy threatens the physical or mental health. In light of the ambiguity in the convention, international law has developed, which considers that right of the mother supersedes the right of the life of an unborn child under this convention. In India, abortion was criminalized under Section 312 of Indian Penal Code till 1971. Abortion was only allowed in cases of emergency when there was a peril to the life of the baby or of the mother. After 1971, abortion was decriminalized and was allowed until 20 weeks of pregnancy, which was later increased to 24 weeks in the amendment made in year 2020 as per the Medical Termination of Pregnancy Act. The child starts developing itself since the day of conception, and allowing women to abort her child should lead to murder by the meaning of this line. But Article 21 provides the right to life only to a person who is existing physically. In the case of Suchita Srivastava versus V. Krishnan, the Honorable Supreme Court of India has held the right of the mother shall override the right of the fetus. A mother has fundamental right over her body, and if she doesn't want to have a baby, one cannot force her to have the baby. Thus, this case summarizes the current legal jurisprudence wherein the right of an infant cannot be equated to the fundamental right of the mother. Now, what are the rights of the unborn child in India? Section 20 of Hindu Succession Act of 1956 acknowledges the right of the child in the womb. It treats the child in the womb in the same way as a born child for inheritance of estate of a dead person. So we can assume that an unborn child should have the same right that a born child has. Section 13 of Transfer of Property Act characterizes an unborn infant as a child or an infant in its mother's womb. The baby is not a living individual, but still the property can be transferred to it. In Section 2E of Indian Succession Act of 1925, it is mentioned that a minor is anyone who's below the age of 18. And as per section 114 of this act, a prior security interest can be made in favor of an unborn child for the corporeal or incorporeal property. The term corporeal property means a property that has tangible existence that can be physically touched, whereas an incorporeal property is neither visible nor tangible. However, that security interest cannot be treated as a vested right until the birth of that child. The rights of an unborn child in India are also shielded with the penal protections. Section 312 to Section 318 of IPC deals with right to life, protection against injury, etc. of the unborn child. Some of the penal protections are: if someone causes miscarriage to the mother. Miscarriage means the deliberate or malified termination of women's pregnancy before the birth of the child. The punishment of this offence depends upon the development stage of the child. If the mother has recently got pregnant, a lighter punishment is awarded. However, if the pregnancy is in advanced stage, this offence attracts a very stringent punishment, including imprisonment for life. Section 313 makes this offence non-bailable, cognizable and non-compoundable. However, it is important to note that if the miscarriage is done in good faith, it shall not be considered as an offence. Injury to unborn child. Section 315 and 316 deals with the offences which involve inflicting an injury on the unborn child. Section 315 is aimed at a feticide which involves the intention of killing the child in the mother's womb itself. Section 316 provides for severe offences that is done with an intention or knowledge to commit an offence of culpable homicide to cause death of the infant. This offence is punishable with strict imprisonment for up to 10 years. In addition, if the mother dies because of this act, the accused shall be charged with culpable homicide. Right of unborn child to claim compensation. In the case of Manikuttan versus MN Baby, Kerala High Court held that if an accident causes death of a pregnant woman carrying a 4-month-old fetus, it shall be treated as taking away the life of 2 people simultaneously. The husband is entitled to compensation not only for the death of his wife but also for the death of his unborn child who was yet to come into this world. The benefit is provided under Section 416 of the Code of Criminal Procedure to the pregnant women. It is inscribed that High Court shall order the execution of sentence to be postponed if the woman to which the death penalty is given is found to be pregnant, and may, if they seem correct, they can commute the sentence to imprisonment for life. In India, an unborn child is vested with numerous rights under different statutes such as the Limitation Act, CrPC, IPC, Transfer of Property Act, Hindu Succession Act, etc. Though a child is not covered under the scope of Article 21 of the Constitution, it is humanitarian duty of the parent to give a healthy and blissful life to the child.